additional terminology regarding the Taft-Hartley Act. Number one is right to work laws, where it means that employees are allowed to choose to not become part of the union if they don't want to. Typically, right to work states are usually in the South that are anti-union. Most northern states are not union shops, although there are some. Right to work states. A union shop means that union and management agree that the employee must join the union within a certain period of time after they join the organization. They do not have to be a union member to get the job, but they have to join the union once they get there. And that's seen in what they call the union shop clause. You're not allowed to require somebody to be a union member. That yellow dog contract, we were talking about that. You can't, well, no, not the yellow dog contract, but you can't require somebody to be in the union to be hired, but you have to require them to join the union afterwards within a period of time. An agency shop clause requires non-union members to pay some union dues without having to be subject to union rules. So they would still pay some degree of fees, but they don't have to be a member of the union and therefore don't have to necessarily follow the union rules about certain things. Free riders are bargaining unit members who do not pay union dues, but to whom the union is still obligated to represent. So anybody who chooses not to be a member, but still is represented by the union is considered a free rider. And then we already talked about the 80-day cooling off period. I spoke about that earlier. The president can order both sides back to the table during a strike or a lockout, if that's going to imperil national health and national safety. So we've seen that when it came to the UPS strike a number of years ago. We saw that with a few other different things. And the goal is we can't have, excuse me, we can't have airports or interstate commerce being affected by a strike or a lockout. Now we move on to Landrum Griffin Act of 1959. It's also called the Labor Management Reporting and Disclosure Act, but Landrum Griffin is perfectly fine. It was enacted in response to investigations into union corruption somewhere in the late 50s, and the goal was that they wanted to establish that union governance is done by a democratic process, that union members have a certain minimum bill of rights, a certain minimum level of expectation of what the union will do for them. And also it regulates the activities of union officials, particularly with respect to how they use union funds. There were a lot of issues at the time with money that was being was disappearing and was not being used fiscally responsible way. So when you're not handling the financial responsibilities of your organization well, and that of the people who are paying their dues to it, that's problematic. Excuse me. So the unions, because they weren't self-managing properly and sort of dealing with these issues internally, the law was passed in order to protect union members, to make sure that the unions weren't taking advantage of them, because the workers are now being taken care of management and the union, both kind of getting on both sides. People particularly who were supposed to be representing them. And it also was really clear more about how we hold union elections. So we have very specific expectations on how a union election needs to be implemented. And overall, this was about safeguarding the union funds for the employees who are investing and making sure that they have everything that they need. Exhibit 15.12 talks about the Bill of Rights, that union members, number one, have the right to attend union meetings, vote on business, and nominate candidates for union elections. That members may bring an agency or court action against the union after exhausting all the union procedures. So basically what this meant was union members had the right to go to court to sue if they have exhausted all the internal procedures embedded in a union and in the union agreement about how to handle inappropriate behaviors on the part of the union itself. Number three, that certain procedures may be followed before any dues or initiation fee increases. So there are certain mechanisms in place to make sure that people know about the increase, why there's an increase, and they can vote on it, etc. Except for the failure to pay dues, members must have a full and fair hearing when being disciplined by the union. Um, so people don't have to pay dues if you don't want to be a member of the union, even if you are represented by them. So you can't make me pay, quote unquote. But anything else, if they violate sort of union policies, whatever, they're welcome to have a full and fair hearing if the union is disciplining them for certain things. Now, if you are a dues paying union member, you've got to pay it, right? But if in particular context, depending on what the collective bargaining agreement is. The collective bargaining agreement says that everybody has to pay dues and that there's no agency shops or maintenance of membership kind of things, then absolutely you have to pay your dues, and there's no way to sue for that. I mean, it has to be part of the collective bargaining agreement and the right to work circumstances. But otherwise, if their union is doing something that you don't like, then you can sue in court through a fair hearing. Next, we'll talk about labor relations in the public sector. It is a very fertile ground for labor organizing. Typically, teachers are considered public sector, first responders, things like that. So this is where labor organizing happens, and it's growing. Federal employees also growing, state employees growing. The U.S. employees, U.S. federal government employees, are exempt from the National Labor Relations Act provisions, and the federal restrictions prevent federal unions from conducting direct bargaining over wages and benefits and from striking. So unions cannot negotiate wages and benefits. They have other things that they can negotiate, but not wages and benefits. That's all set by civil service, and they cannot strike. And this was the thing that happened with the air traffic controllers, PATCO. What happened with PATCO was they put their money and their vote behind Ronald Reagan when he came into office in 1980, and they wanted certain concessions, and then they asked for a pay increase and various other things, and Ronald Reagan said, no, I'm not going to do that. So they said, if you don't do these things that we want, we're going to strike. And he said, you can't strike. You're not allowed to strike because you're a federal employee. And they struck anyway, and he told them that they had one chance, that they could come back to work by a certain date or they would be fired. And many of them came back, but many of them did not, and they were fired. And so we had a glut of air traffic controllers um, out of work, and a huge gap in a high need and not enough employees doing air traffic control work. We actually moved people into positions that had little experience and little training doing that work. So sort of traveling in the early 80s was a little scary there for a while because we did not have um, properly trained air traffic controllers. It is a very high stress, very, very difficult job to do. It is not one you take lightly, and unfortunately, um, uh, that has had lasting impact on bargaining and strikes and union power pretty much since the early 80s. Um, the Civil Service Reform Act of 78 established the Federal Labor Relations Authority to administer federal sector labor law. So not the NLRB, but the FLRA, it manages all federal sector labor law and have done so since 1978. State, county, and municipal public employees can also be a part of a public sector union, and typically it's broken into three different types: professional associations, craft unions, and industrial type unions. The largest professional employee organization in the public sector is the National Education Association, and that represents teachers. The difference between public and private collective bargaining is that the federal legislation and most state statutes do not contain a right of public employees to strike. Although there are, as you can see there from the note, that um, there can be things like the blue flu, which basically word gets out that a lot of people show up sick. And they'll allow for a skeleton crew, but a lot of people will call in sick for the day. And it's a way of following the rules, but at the same time making your point known that, yeah, I'm not going to do this overtime. I'm not going to do this extra work that you expect of me because you are not bargaining in good faith, or you're not treating us properly. So even if they can't formally strike, you can do things informally to just put pressure um, on the employer, which is the government, to discuss the issues that are of concern to you. Management tips. If employees consider unionizing, do not try to negatively influence the decision in impermissible ways. Can you tell the truth about union costs? Absolutely. Can you tell the truth about what unions can do right and what they can do wrong? Absolutely. Can you fire somebody for trying to organize, or punish them or not promote them because they want to unionize? Absolutely not. Those sorts of tactics come back to bite you because it increases the likelihood that people are going to want to unionize anyway. Best way to get rid of a union, or to not have a union organize you in the first place: pay people fairly, treat them well, and make sure that they have all the things that they need to be able to do their job. It's really easy. It's not a difficult formula. Number two, do not assume any employee you speak to for the purpose of persuading employees not to unionize will keep the conversation confidential. Just because you think you're talking to somebody one-on-one who's going to be treating things confidentially does not mean that they will. Don't assume that even if someone tells you that it'll just be between the two of us, that it actually will stay between the two of you. It doesn't work that way. Know the kinds of things the employer can legally do to influence the unionization decision, and do not do anything other than what is permissible. So again, be clear about what you can and cannot do, and make sure that you only do the things that you can do, because it does come back retributionally, increasing the likelihood of unionization occurring. Once the union is in place, conduct all your negotiations only with the union rep. You cannot individually negotiate with employees about salary related issues or anything else. Only the union is the entity with which you can negotiate, and the representatives of the union. And usually the union negotiating team is represented by your business manager, your shop steward, and a number of other individuals who are in the bargaining unit that are tasked with the responsibility to do the negotiation. And so you can only speak with those individuals. You cannot speak with people outside of that negotiating team. Treat the collective bargaining process as one would any business activity. Transparency, a fair and reasonable expectation of bringing your best effort to the table, acting like any other kind of negotiation. It's not cutthroat. It should be integrative. It should be finding a win-win, not a I win, you lose situation. If we can figure out what we can do together to make an agreement work, that's what makes the most sense. Know what the law requires, such as what the employer can and need not do. Um, and so again, be clear about what the law says, the labor law says, about what is negotiable, what is not negotiable, and what can be negotiated if you choose to do it. So be very clear about what are at your discretion and what is at labor's discretion. Always keep communication open. Any negotiation is about a dance and communication, and making sure that we have transparency and that we're not trying to manipulate people. The goal is, influence is one thing, manipulate is an entirely different animal. So we're going to keep that lines of communication open and do that dance and do the dance that we need to do to move things forward. Try to keep that us versus them mentality from having a negative impact on the collective bargaining process. Again, when we focus on integrative bargaining, which is a win-win circumstance, that's a much better approach, because what we're looking at is the baseline needs for everybody, and it's about issues based. situation, and what is my bottom line need? What is your bottom line need? What is it that we really want? And how do we get to a place where we can negotiate with good faith between us? When we approach it as a win-lose situation where it has to be distributive, like there's only a small set of resources and either I'm going to get them or you're going to get them, we're not going to both get them, that's more problematic. So it is very important for us to make sure that we are approaching this in a win-win scenario. Play hardball without setting management up for an unfair labor management practice. So what we mean by play hardball is don't give away everything easily, right? I mean, if you they're going to want things and you're going to have to figure out what things matter to you the most, what things are less important to you, what things you're willing to give away, what things you're not willing to give away. Know where your bottom line is. We call that BATNA when we're talking about negotiation. It's the best alternative to a negotiated agreement, BATNA. And our goal in determining our BATNA is this is the stuff that I minimally have to walk away with. Everything else after that is icing on the cake. And the union's going to do the same thing. So we want to make sure we're set up in such a way to know what it is that we want and what we're willing to give away, what we're willing to negotiate on, and where that boundary is. But that doesn't mean that you can't, you don't always have to say, well, my bottom line is, you don't start with your minimum that you need. Obviously, we always want more than what we can get. But that doesn't mean that we wouldn't still have a win-win situation in mind when we're trying to get there. This is a real scripted, negotiated dance. And people really don't really understand that it's a game in many respects. It's a dance that we do because it's about the give and take, and it's about figuring out what you value versus what I value, and what I want versus what you want, and how we're going to get to where we need to get to in the end. And that's important.